Welcome to Judicial Service Commission YouTube channel. My name is Samuel Mugisa. I work as the Acting Registrar, Education and Public Affairs at the Judicial Service Commission. You may need to know what Judicial Service Commission is. Judicial Service Commission is a body that was created by the Constitution of Uganda of 1995 to do a number or several things you will see from its functions. One, it advises the President in exercise of his power to appoint the Chief Justice, Deputy Chief Justice, Principal Judge, Justices of the Supreme Court, Justices of Appeal, Judges of the High Court, Chief Registrar, and Registrars. Two, there are other judicial officers below those I have mentioned. All of them are appointed by the Judicial Service Commission. They include Deputy Registrars, Assistant Registrars, Chief Magistrates, and all magistrates. In addition, the Commission appoints the other administrative and other staff of the judiciary. And the Commission receives and processes people's complaints about the judiciary and administration of justice generally, and thereby acting as a link between the judiciary and the public. The Commission also reviews and makes recommendations about terms and conditions of service of judges or judicial officers and other staff of the judiciary. And like what we are doing right now, it is also charged with the function of preparing and implementing programs for the education of judicial officers and dissemination of information to the public about law and administration of justice. We want to take this opportunity to welcome you to our channel, and we'll start by discussing the regulation of non-deposit taking microfinance institutions in Uganda. What is a non-deposit taking microfinance institution? A non-deposit taking microfinance institution means a company or a non-government organization licensed under Section 62 of the Tier 4 Microfinance Institutions and Moneylenders Act of 2016. This type of microfinance institution is not allowed to take deposits in the form of savings. You may know some in your localities. They only lend, but they don't take people's deposits. They don't keep your savings. Those are the ones we are referring to here. There is a set of regulation for these businesses. So we need to know what that business of non-deposit taking microfinance institution is. The business of non-deposit taking microfinance institution is to extend microloans to small and medium businesses and individuals. Then what is a microloan? A microloan is defined in the Tier 4 Microfinance Institutions and Moneylenders Act of 2016 to mean a loan of an amount not exceeding 1% of the core capital of the non-deposit taking microfinance institution for an individual borrower. Or, that is B, 5% of the core capital of the non-deposit taking microfinance institution's total capital for the group of borrowers. In case you have a group which is borrowing, then the micro loan is pegged to 5% of its core capital. If it's an individual, then it must be 1% of its core capital. Then who supervises the non-deposit taking microfinance institutions? They are supervised by the Uganda Microfinance Regulatory Authority. The functions of the Uganda Microfinance Regulatory Authority in respect to non-deposit taking microfinance institutions include the following. The authority is responsible for regulating, licensing, and supervising the Tier 4 microfinance institutions and money lenders. It also promotes programs and interventions that are necessary for the development of the Tier 4 microfinance institutions. It protects the interests of the members and beneficiaries of the Tier 4 microfinance institutions by promoting transparency and accountability. The authority ensures the stability and security of the Tier 4 microfinance institutions. It also charged with the responsibility of establishing and enforcing standards of sound business and financial practices for Tier 4 microfinance institutions. The authority conducts periodic reviews of the activities of the Tier 4 microfinance institution. The authority is also supposed to prescribe the minimum capital requirements and many other functions in order to fulfill those, or in line with those that I have mentioned. If you want to do that business, how can you apply for a license to do a business of a non-deposit taking microfinance institution? One, you have to make an application in writing to the Uganda Microfinance Regulatory Authority, which you must accompany with a certified certificate of incorporation for a company issued by the Uganda Registration Services Bureau, or a certificate of registration for a non-governmental organization. Two, the memorandum and articles of association, that is in respect of companies, or a constitution, or other documents of incorporation if the entity is not a company. And then you must put a management structure of the company or a non-governmental organization. Then you must avail evidence of payment of a prescribed application fee, which stands at 50,000 Uganda shillings. The Uganda Microfinance Regulatory Authority is located on Rwenzori Towers, Plot 6, Nakasero Road, Block B, on the ground floor. You can visit it for more information. How can one know if a non-deposit taking microfinance institution is licensed? The authority is charged with the responsibility of publishing in the Gazette and in at least one newspaper of wide circulation in the country a list of licensed non-deposit taking microfinance institutions at the beginning of each year, in any case not later than 31st of March. So in case you visited one and you don't see their license, you can refer to the authority and cross-check if that non-deposit taking microfinance institution is licensed in respect of the period of your transaction. So when is a non-deposit taking microfinance institution required to renew its license? A non-deposit taking microfinance institution is required to renew its license 90 days before its expiry. The license is usually for 1 year. So before the year expires, That means in the fourth quarter of the year, it should apply for the renewal of its license. Usually, it's a legal requirement that the loans, the microloans extended by a non-deposit taking microfinance institution are denominated in Uganda shillings. And these loans may be given with or without collateral. Collateral is the security which is given to secure the repayment of a loan. The non-deposit taking microfinance institutions are required to exhibit transparency. But how do they do this? They exhibit transparency by furnishing the borrower with accurate information on the procedure and condition for microlending. The information must be very clear so that the borrower knows from the start what he's supposed to do in order to borrow money from the microfinance institution. Secondly, the borrower, before he borrows the money from the microfinance institution, he should know the costs associated with obtaining and servicing the loan by the borrower. Many of them are shocked after the loan has been given to realize that the costs associated with extending or obtaining that loan are way higher than what they are possibly willing to pay. The microfinance institution also exhibit this transparency by maintaining confidentiality of information relating to its borrowers. Also, they must inform the borrower of the rights and duties associated with the acquisition of a micro loan. Some of the microfinance institutions, for example, do not tell you that you have a right maybe to pay early. And when you pay early, they should tell you whether they will charge you or not. Of course, the best practice now is that if a borrower pays early, is not charged for the period unused, but some institutions still charge a small fee. So, what information must be contained in a loan agreement between a borrower and a microfinance, a non-deposit microfinance institution? Of course, the agreement must have the name of the borrower. The agreement must have the amount of the loan. Does it happen all the time? No, there are instances when you have been handed over papers to sign without stating the amount of money you have taken. But this is now a legal requirement. The non-deposit microfinance institutions must comply with. The other requirement is that the period you have been given for that loan must be stated clearly. You do not borrow indefinitely. Then the maturity date and the repayment schedule of the loan. That is almost similar to the one above, where you must show that if a person pays regularly on a monthly basis, if that is the agreement, or on a weekly basis, then every such a period you will be paying so much and it would last so much, so that he knows by this end date the loan will be fully repaid if it has been paid on schedule. Then they are required also to state the amount of interest to be paid over the course of the loan. If you have borrowed for 1 year, then you have to state at the end of 1 year how much interest will you have paid. Some of them do state their interest on a monthly basis. They will tell you 2%, 3%, 5%, or 10%. Assuming that you have borrowed at 10% per month for 12 months, how much interest will you have paid? You will have paid 120%. So that needs to be stated clearly. If you borrowed at 5% for a year, how much interest will you have paid? You will have paid 60%. And if you borrowed at 3% for a year, that translates into 36%. That requirement, there is that requirement for the non-deposit microfinance institution to state to the borrower. Sometimes when you do not pay according to schedule, there are penalties they charge. You need to know at the time you are taking up the loan. In case of default in fulfillment of the obligation, how much money you will be paying. The agreement should also state the security or the collateral which has been given for that loan and the procedure for settlement of disputes. Many people just borrow agreements and say, in case of dispute, it will be settled by arbitration. You need to understand that if that is the procedure stated, then you have an obligation to follow it before you take recourse to say court. If you do, then the court will send you back to first fulfill that because it is now part of your agreement. The agreements must bear the signature of the borrower. It might be obvious, but you know sometimes you are borrowing over the phone and sometimes you are not in the same place, but then the agreement will be kept. But there are other means of ensuring that your signature can be obtained. Then it must indicate the method of calculating the interest rate. I think that one is obvious, but one needs to know how is interest rate calculated. Then you can be able to know how much that loan is going to cost you after factoring in the interest rate and the other charges, other costs for the loan. There is an obligation on the part of the non-deposit taking microfinance institution to avail its clients with the procedure for loan application and approval, to avail a micro loan agreement, the amount of the loan, the interest, the schedule of repayment, and the performance of the micro loan agreement. It is an obligation for the microfinance institution to furnish, at the request of the borrower, a statement on how he has been paying or servicing his loan. And there is a responsibility of the parties in the event of non-performance. If a borrower borrowed money and failed to repay, what happens? Usually, if there is a collateral or security that has been given, the lender is at liberty to realize the security in accordance with the terms of the loan agreement. If there is no security, then a cause of action will arise. He can take you to court and sue you for recovery of the money extended to you. There are things a non-deposit taking microfinance institution is not supposed to do. One of them is to raise monies in form of deposits from individuals. Right from its name is a non-deposit taking. So it is prohibited from taking deposits from individuals. 2, to act as a surety for the obligation of shareholders or a third party. Remember, this is a company which is in the business of micro lending. Now, it cannot be a surety, it cannot guarantee payment of a loan of its shareholders or a third party. Why? Because you'll put its business at risk, which will also risk the interest of its customers or its clients. The third thing they are not supposed to do is to lend loan insurance funds. Sometimes lenders or institutions in this business of lending money require that a loan be insured. And that that amount of insurance is charged on the customer. So they may feel that the risk is not likely to occur, or they may take the risk, and instead of insuring against the risk, they put aside the money and lend it out. Why? They know this money will generate more income than paying it out to the insurance company to secure their lending. So the temptation is very big, but it's for that reason that the law provides that money should not be lent out. Then the non-deposit taking microfinance institution is prohibited from providing collateral for its members or third parties. You cannot use it as security in itself or to give security for the borrowing of its members or third parties. And finally, the other thing they are prohibited from doing is to dispose of its assets, the assets of the non-deposit taking microfinance institutions, which may result in a 10% reduction of that asset without the approval of the Uganda Microfinance Regulatory Authority. Remember, we talked of a microloan being pegged to the capital of the asset. So when the asset is sold off and there is a reduction, it means that the capital of the microfinance has reduced drastically, which would affect the extent of the loans they extend to individual clients or groups, as we saw above. But they are not stopped from selling their assets. All that is required is seek the approval of the authority, and if the authority finds that it's appropriate, it will approve or it will permit them to do so. So, what constitutes the finances of a non-deposit taking microfinance institutions? Remember, we said that they do not take deposits. So how do they raise those finances? One is voluntary contribution by one or more of the promoters, the people who have started the company or the or the NGO which is involved in that business, they pool resources that constitute the capital which they use to lend out. Number 2, donations and charitable contributions from third parties. We have donors who have donated to non-government organizations for charitable purposes in order to use the same money to lend it to people or to a cause that they have identified. So that is one of the sources. I think there are many around you. I may not be able to pinpoint at some right now, but there are many around you, around church organizations, around NGO organizations that extend manageable loans to people, and those monies come from donors. Then we have grants and non-repayable special purpose financing from local government or government. Government has programs, and if they identify an institution which is a non-deposit taking microfinance institutions, it can put in money to be extended to the categories vulnerable or people the government has identified that ought to benefit from such grants. Then they do business themselves, so one of the sources is earning from those activities that they are licensed or authorized to do, that raise money. That's how they raise the money that they lend out. And finally, a non-deposit taking microfinance institution can raise money from loans and credits. Credits and loans, the same thing, not necessarily. A credit is you can acquire something without paying for it immediately, and a loan is specifically money you borrow for a specific purpose. So those are the sources that these non-deposit taking microfinance institutions are authorized to raise money which they use in their business to lend out to its clients. Like all other organizations, a non-deposit taking microfinance institution is required to make annual reports. And these reports, they submit to the authority. Authority here, we mean the Uganda Microfinance Regulatory Authority. And this report should be submitted 3 months after the end of a financial year. Of course, we know that under the Companies Act, there is also a requirement for companies to file their annual reports, and also the NGO Act requires NGOs, non-government organizations, to file their annual report. So there is that requirement. Thirdly, the annual report of the authority should contain the following. But that is to the authority. The microfinance is the one making an annual report to the authority, and that report should have audited financial statements. It should show a structure of management and also any other information as the authority, the Uganda Microfinance Regulatory Authority, may specify or require that should be included in the annual report. Records. A non-deposit taking microfinance institution is required to keep records relating to a loan transaction for at least 10 years. So can a non-deposit taking microfinance institution change management? Yes, it can change management, but that change must be authorized in writing by the authority. Now, if a borrower has given collateral or has given security to secure the loan, what are the obligations or responsibilities of a non-deposit taking microfinance institution? One is where a non-deposit taking microfinance institution obtains collateral for securing a loan, it shall ensure that the collateral is duly charged and adequately insured. What do we mean by duly charged? When you take collateral which is immovable, that is land, that's building, it means this land, you have to register a charge on it in case this land has a land title. Of course, if it doesn't have, there is no way you can register a charge on untitled land. For being adequately insured, the insurance definitely looks at the value of the collateral and gives the appropriate insurance in case of destruction of that collateral. Some of the collateral is immovable. There is a law that regulates how you handle immovable property as a security for loans. Also, that law will require you to have a charge registered so that they know this property you have given may be animals in your farm, may be property in your home, machinery, and all that is charged. And that registration is done with the URSB for collateral which is movable. I hope we'll have some time also later in another video we could talk about how that security is supposed to be handled. Is supposed to maintain a register which is up to date on the collaterals provided for securing all the loans. The authority has power to inspect those books, and one of them they would want to look at is your security register to know what securities you are handling. Then it has a responsibility to undertake evaluation and obtain a first sale value of collateral and the market sale value of the collateral before carrying out a sale by public auction or private treaty. We have said that in case of default and the loan is secured, then the lender, in this case the non-deposit taking microfinance institution, has power to realize or to sell the security in order to pay back the outstanding loan. But before it can do that, then it must undertake evaluation of that property. And secondly, as they do the evaluation, they must tell what is the first sale value of that security. Similarly, they have an obligation to give a notice to the borrower of at least 60 days before they can sell off the collateral that has been given for that borrowing. And they also have an obligation to ensure that the collateral is not sold below the first sale value in at least the initial or the first two auctions. We mean if you have brought a motorcycle which is securing a loan, and the borrower has been notified after 60 days, the lender chooses to sell it through an auction, the price must not be below the first sale value. If after 2 attempts, still the sale fails, then it can sell at whatever price. But of course, what is reasonable, considering what has been stated as a first sale value. You might have a car, and the car is valued at 60 million. The outstanding loan is 30. They tell you the first sale value of this car is 45 million. You try to sell it, the bids, what you get is the offers are below 45 million. The first one fails. You attempt another one. They still give you 40 million. But the first sale value is 45. You are still not allowed to sell it off. But you can subsequently sell. And of course, what is needed here is the evidence that these auctions were carried out and they were not concocted. The evidence usually is in the adverts inviting for bids and things like that, and to see what happened during each auction. And after selling the property, the proceeds of the sale of the collateral are supposed to apply as follows. 1, towards the repayment of the monies which are outstanding on the loan. If you've sold the collateral and what is outstanding is 20 million, you realize the 45 million, then the first charge will be to clear off the outstanding 20 million. And then you will have a balance of 25. That balance of 25 can now be applied to the recovery of the costs and expenses which were properly incurred or that were incidental to the sale. Advertising costs, the bailiff's costs, the auctioneer's costs, storage costs, and things like that, which are properly incurred. The word here used is properly. So you don't create expenses which might not be really incidental or associated with that sale. Then the balance, if there is any balance which is remaining, it is supposed to be paid to the borrower. My personal experience, what I've witnessed see or go on the market is a highly valued security is sold below the first sale value, and the lender wants to take all the money. Maybe you might be demanding 10 million, sell security of 30 million, and it takes all of it. Sometimes he wants to take the security itself. Remember, under the mortgage law, security is security. You cannot take security which has been given to secure a loan. You cannot convert it into your own unless you get even the permission of the court to buy it. That is to ensure definitely there is a conflict of interest and that the borrower will not get justice or fairness if you allow the lender to dispose of the security as he pleases. The business of non-deposit microfinance institution is not supposed to be closed without the approval of the authority. The closure here, we mean permanent closure. You don't just walk away. If you have been licensed to do this business, you must go through the formal process of closure, such as liquidation, takeover, mergers, something like that. And before you do that, you must give notice of at least 90 days of the intended closure so that you can close off business. And I think the logic is very simple to see here. You're holding people's securities, and possibly they are more valuable than the outstanding loans. So when you close and they disappear, who's then accountable? So that is the rationale, to make sure that once that notice is given, if somebody had cleared his loan and had not collected his security, he can be able to collect it. Thank you for watching us in the discussion of today's topic. You may have questions. In case you have any more questions or clarification you need, you may contact the Judicial Service Commission on toll-free numbers 0800 100 221, or you can email info@jsc.go.ug, or you can visit our offices at Kingdom Kampala, 8th floor, plot 31 to 35A Nile Avenue. Thank you very much.